Good morning, everyone. Thank you for the introduction, Senator Richards. Good morning to the Honorable Minister, His Excellency, all other and special invited guests, especially David and Angel, who both traveled a very long distance to be with us here this morning. And welcome and good morning to all our guests here today. So it seems as though the theme for today's legislation, it seems to be a running topic among most of the presenters here today. And I think it's very appropriate for me to begin this morning by speaking a little bit about how legislation can support you. A lot of people tend to say that, well, the legislation could be there, but you don't really need the legislation for change. But we have the view that the legislation sets the groundwork to have that trickle-down effect, because ultimately what they're saying is it takes persons to change their perception about persons with disabilities. It takes a cultural change. That's really what they mean when they say we don't really need the legislation. But the legislation is the first step in initiating that cultural change. Because if the legislation is not there, then what is really saying that persons with disabilities have equal rights as everyone else? So, in terms of how legislation can support you, the theme for World Down Syndrome Day this year is improving our support systems. When we say improve our support systems, what do we mean? It boils down to three things: choice, control, and dignity. Persons with Down syndrome should be equipped with the tools to enable them to make choices for themselves. This is choice. Persons with disabilities and persons with Down syndrome should have control over their lives or have a sense of autonomy, control. And dignity. Persons with Down syndrome should have a sense of pride in themselves and command respect from others. Legislation can support persons with Down syndrome in achieving these three things by ensuring equal access. Equal access to education, to employment, healthcare, access to information. The list will go on, but I will focus on what we consider the two of the pillars today, education and employment, because these are the two that we believe form the foundation for persons to gain control over their lives. The role of the legislation in terms of improving support systems and promoting equal access to education and employment, which will ultimately give persons control, choice, and dignity, is that it will establish frameworks, it will outline responsibilities, it will promote and protect fundamental human rights, it will prohibit discrimination and promote equality, and it will ensure equal access. Senator Richards touched on the issue about the gap in Trinidad and Tobago in respect of disability legislation and the absence of it. We do have the Equal Opportunities Act and the Equal Opportunities Commission and the tribunal formed under it. However, there are significant gaps within that piece of legislation which does not accord with the UNCRPD, which is really the international standard. So while the Equal Opportunity Act prevents discrimination, it doesn't outline rights. And we need the legislation to specifically outline rights and put positive obligations on parties to ensure that those rights are enforced. So we'll go into the two pillars briefly. Education and employment. The first one is education. When we say education, we are talking about equal access or non-exclusion. We are talking about an accessible environment. We are talking about accessible formats of communication. And we are talking about trained personnel. So we acknowledge the draft bill. The draft bill does in fact deal with equal access to education. However, we want to emphasize the frameworks that need to be placed within the education system to support equal access. So what happens after you get equal access? And that's where the trained personnel comes into play. So it requires a total reform of the education system to ensure that the personnel who are then placed in these schools are one, trained. But before that, we need to ensure that we have the numbers in the schools as well. Because what or how helpful is equal access if persons with disabilities aren't able to be effectively involved, if they aren't able to effectively contribute? Because we also need to remember that we need to focus on them living up to their full potential, and they could only live up to their full potential if it is they are given the trained personnel in the classroom. So equal access is important, but focusing on what needs to happen after that is more important. The second topic is employment. Prohibition of discrimination in the hiring process. Again, accessible environment, reasonable accommodation, and affirmative action. My apologies, I should be affirmative, not affirmation. The topic within employment that I'd like to focus on is reasonable accommodation and undue hardship. Reasonable accommodation means that when it is you do hire a person with a disability, the employer is under an obligation to make certain changes in order to accommodate whatever different or special needs that person may have. It's important to note reasonable accommodation because it goes hand in hand with undue hardship. So the bill does try to strike a balance between these two things. So it says, yes, an employer has to reasonably accommodate a person with a disability, but it also says that undue hardship is one way where an employer can be, okay, well, I don't have the resources to put these things into place to accommodate these persons with a disability. It's important that when we are drafting the bill, we ensure that this undue hardship provision is not too broad to make it a scapegoat for employers to say, this is undue hardship, and that's the end of the story. So I just want to touch on specific issues within education and employment. I don't want to go into all of the topics because I will go way over the time. But these are just a few things to note, right? Lastly, and perhaps most important, enforcement. So one of the big problems with the Equal Opportunity Act is in relation to enforcement. Number one, there's a strict time limit. You have to file a complaint within 6 months. I mean, if you're talking about persons with disabilities, these are persons who have been systematically disadvantaged. They may not be aware of their rights. They may not even know their right was breached. It may take them a longer time than the average person to be able to figure out that they have a right to enforce. So if there's a 6-month time limit on filing a complaint, then you are restricting their ability to enforce, their rights. So another gap with the Equal Opportunities Act is the commission is the one with the first say to say if your complaint is worth pushing forward to the tribunal. So there are like hurdles before you are able to reach to the tribunal to have your rights vindicated. And this is aside from the definition of disability, which is still a medical definition in this act, not a social definition, which I would say restricts what is considered a disability. So it's not as easy as it seems on the surface to even qualify to bring a claim under this act. So when we think about enforcement moving forward in the new bill, while we acknowledge that we already have a specialist tribunal in place, it may be worthy to consider perhaps giving concurrent jurisdiction to the High Courts of Justice to ensure that persons with disabilities are not stymied in their ability to bring a claim to vindicate their rights. So I will end there today, and I will also like to remind parents that when the act does come into place, to try to inform yourselves. Legal writing can be daunting to read, but at least know your route to enforcement. So when it's time for you to have those rights vindicated, you are aware of what you have to do. Because it's only when we choose to enforce thereafter does the change really happen. Thank you, everyone, for your attention.